We're going to discuss about the people who got the green card, but their family members did not get the green card in the employment-based category. Especially as we know that in October of 2020, a lot of rush came in, a lot of people filed the adjustment of status, and there was a mad rush by the immigration in approving the green cards, and some of the family members got segregated from the main applicant. The main applicant got the green card and the family members did not get the green card. What are the options for them? Now, since the priority date is backtracked right now, let's say, for example, if their priority date is in 2013 or 2014, and now it's backtracked, what are their options when only one family member gets the green card and the other family members did not get the green card?
Yeah, you really have three main options. The first would be to do nothing, just wait. And let the priority date become current again. And at that point, the dependent's green card will be adjudicated in the employment-based category. So if your priority date is close to April 2012 to where it might become current in the next couple of months, this might be a good option for you. You don't need to take any additional action. But if your priority date is further away, where it could be months, it could be years before it becomes current again, and you don't want your family members to be in limbo for that long waiting for the 485 to be approved, another option is to use the family-based category, which is the F2A category. As a spouse or child of a green card holder, they can receive the green card that way. There's two ways to do that, depending on the dependent's status. So if they are having their own non-immigrant status to where they were not tied to your status. So let's say you were in H-1B status and your spouse was in H-4. When you got your green card, you're no longer in H-1 status. That means your spouse is no longer in H-4. Then they didn't have their own independent status. But if you both had H-1B and when the main applicant got their green card, the spouse is still in H-1B, then the second option could work for you. And that is to file an I-130 family-based petition and a new 485 application based on this family-based petition. So I-130 is just like an I-140, except for I-140 is employment-based, I-130 is family-based. But the process is the same. You file that I-130, and if your spouse and children are maintaining their non-immigrant status, they can file another 485. And then the third option, if your family members are not maintaining their own non-immigrant status, they can't file the 485, but you can file another I-130 petition and then have them consular process the green card. And during that, they can actually stay in the U.S. based on their pending 485, but then when the family-based case is ready to go, they can leave to attend that green card interview and come back if that's a faster option.
Emily, you said the first option is do nothing. I mean, if the prior date is 2015, the main applicant got the green card. Why can't the dependent be given the same priority date and get the adjudication done? Why do they have to wait the priority date to go back current?
Right. Unfortunately, when the date is not current, that means no green card is available for that person. So the visa number was not allocated to the dependent at the time that the main applicant got it. So they have to wait till a visa number becomes available, which is when the date is current again. Only then will they be able to have the 485 adjudicated.
Can I not contact with congressman and to make sure that my dependent case gets approved even though the priority date is not current?
No, if the visa was never allocated and the date is not current, there is nothing a congressman can do. It's against the law for you to receive a green card at this time.
How about can I sue the USCIS in the court saying that why did not you approve my dependents at the same time?
Yeah, unfortunately, same thing. There's nothing the court can do because they can't tell USCIS to give a green card when there isn't one available.
Emily, you said the second option is if they are maintaining the non-immigrant status, maybe F1, maybe H1B though. You said that they can file an I-130 and 485 application though. Why can't we file just I-130 application and do the transfer of underlying basis from the employment base to this I-130 application?
You technically can, but as we talked about many times before, prior to January 2022, there is no process for transfer of underlying basis. So time and again, we would send a letter, call USCIS, contact a congressman, contact the ombudsman, send another letter. It takes forever to get that done.
And eventually we end up filing the 485 for them.
So although yes, you could technically do that, it just doesn't work, and there is no supplement J process to request the transfer of underlying basis for family base like there is an employment base. So we don't recommend that and would recommend filing a second or possibly even third 485.
Emily, in the case where we are filing a 485 application, F2A is almost all the time current, and we file the 485, do you recommend filing an EAD in advance parole with it?
I would, simply because they're free. There's no additional filing fee for that, and that way you're not having to worry about, can I use my other EAD or AP to travel? How's that going to impact my second 485 filing? Go ahead and apply for them and get them with every 485.
Emily, you said the third option is, for example, if they are not maintaining the non-immigrant status. That means that the main applicant is an H-1B and the dependent is an H-4, or maybe the person may have used the adjustment of status EAD, in which case they are not maintaining the H-1B, neither they are maintaining the H-4 status. The third option is that we file an I-130 with the consular processing. So when we file an I-130 in the consular processing, don't they have to stay in India or whatever their home country is? Can they stay here while the whole process is going on?
Yeah, they can stay here because they're already here. They're lawfully present based on the pending I-485 from the employment based. So they can rely on that for their U.S. status. And while that is happening, they can be seeking the green card through the family based at the consulate. So you can stay here the entire time that your employment based 485.
Because their adjustment of status is still pending in the employment based. They can continue working on the EAD that was being given. But at the same time, when the priority date becomes, when the interview date comes, they just show up in the Bombay consulate, Mumbai consulate, and then get the green card and come back and say goodbye to the adjustment of status. These people need to be very aware of it. The reason is that sometimes the priority dates move a lot later than what you think. Sometimes they move in just a span of 1 month, they move for 5 years. But there are periods of time that it takes almost like 9 years actually, especially in the case of May 1st of 2010 priority date in May. It took 9 years to move the priority date 1 day. So you might want to consider these other options. Option 2, which is filing the adjustment of status, adjustment of status. Option 3, filing the consular processing. Emily, if I have an adjustment of status pending in employment based on my primary applicant, is that going to be conflict if I file an I-130 and adjustment of status again? No,
no problem at all. You are completely allowed to seek any different option for the green card. You know, when we did our downgrades and then people refiled, we went through this before, you can have multiple 485s pending. And you can also have an I-140 based application and an I-130 based application. There's no conflict between the two.
What about when we have one adjustment of status in the employment base? Can we have one consular processing in India? Isn't that a conflicting thing?
No, not at all.
Any other questions, Emily, that you want to ask?
Yeah, so what is the process? Let's say someone has to do consular processing and they file that I-130 and it gets approved. What happens next?
Then it goes to the National Visa Center. Then we have to pay the fees that is required there. And after that, from the National Visa Center, it will be transferred to the consulate. The consulate will send an interview notice. The individual has to go there and get the interview done. Now, of course, before that, they have to submit the police report, medical reports, I-864. They have to submit all those things when they go for the interview. They have to, before that, they have to submit and then they have to go for the interview.
Yeah, so there are a few differences between employment-based and family-based. So one is the affidavit of support. The sponsor, the green card holder, has to show that they have the financial ability.
Which most probably, if they have a $60,000 or more per year annual family income, they should be fine.
Mm-hmm. And then the applicant will have to get a medical exam done in their home country and take it with them to the interview. And the applicant also has to have police clearance certificates from every place in the world they've lived besides the United States. And they have to submit that to the National Visa Center.
Which normally is not that hard to obtain, especially in the counties here in the United States and also in the home country in India, especially if they're from India. That shouldn't take much time. And these things can be worked out after we file an I-130, before it goes. National Visa Center calls us to submit it, we can get those things done. And if you guys are interested in us processing if you want to take the option 2 or option 3, if you're interested in, I will put a link of a Google document. You can fill out information, then we'll give you the Zoom information where you come and speak with us and discuss with us the options what you, if you want to go with us, what are the charges, what is the information we would require from you, and how much time it's going to take. Normally, if you file an I-130 and I-485, it's take anywhere between 1 year and 2 months to approximately about 2 years is the processing time. When you file the consular processing, it almost takes 2 years for you to get the green card though. And as Emily has pointed out, and we both have been pointing out, that it's not a conflict, that 2 applications are pending. They can parallelly go, and there is a good chance you may benefit. There is a chance you may not benefit. Who knows? The priority date might go all the way to 2015, and you might still get the green card. Then definitely this second and third process may not be useful if the priority date goes forward to all the way January of 2015. But if the priority date doesn't go, sometimes it may take 10 years to go. This second process and third process will come for your benefit. Anything else, Emily?
That's all I have.
We have provided the links. If you want to have a consultation with me, Emily, or any of our colleagues, you can put you can go to the link. One of the other lawyer who handles these things in our office is Vanita Diwar. And we have also put a Google document there. If you're interested in, you can fill it out. We'll give you a Zoom information where you can attend the particular. This is only for people whose main applicant got the green card and the rest of the people did not get. Surprisingly, there are so many people, and we are doing this only because we got so many calls from the people. Oh, I got my green card. My wife did not get it. My child did not get it. That's the reason we are doing this session. Thank you very much.